Good morning, everyone, and welcome. We're pleased to have you with us today. We had 3 cases on the morning docket, but one has been moved to next month, so we will gladly hear the 2 that remain, and we will hear them in the order in which they appear. Let me remind counsel that each side has a total of 15 minutes. That's whether you have 1 attorney or 3 attorneys arguing. So if there's more than one, you'll need to share that 15 minutes. Also, the appellants have the right to reserve up to 5 minutes for rebuttal. So when you come to the podium after you've introduced yourself, please let us know how many minutes you would like to reserve, and we will program the clock accordingly. Are there any announcements or introductions? Hearing none, please call the first case.
Elijah Shaw et al. Versus Metropolitan Government of Nashville and Davidson County.
Good morning.
Good morning, Your Honors.
Good morning.
My name is Paul Avalar. I represent plaintiffs, appellants, homeowners, Lyd Shaw and Pat Rayner in this matter. I'd like to reserve about 4 minutes for rebuttal, if I may.
4 minutes, yes.
Your Honors, Rule 56 guarantees us a legal decision based on undisputed material facts, and the summary judgment decision below is untethered to those facts. And so the question for this court is, I think, relatively simple. Do facts matter under the Tennessee Constitution's equal protection guarantee? And they do. Plaintiffs made the evidentiary record that the courts say they need to in order to win. They've shown that they are harmed by the challenged client restrictions, that they are similarly situated to the privileged home-based businesses, and the privileged home-based businesses are exempt from those restrictions. By comparison, Metro only relied on 4 facts, none of which went to the essential elements of an equal protection claim. And so the summary judgment decision below ignored both those facts and also the nature of an equal protection claim. It's not a substantive due process claim. Even if there is a good reason to regulate home-based businesses in Nashville, the question is, can Metro regulate similarly situated home-based businesses differently? And the answer is no. There is not, and certainly not on this record, where the uncontested evidence shows that customers to the plaintiff's home-based businesses are the same, or in fact less obtrusive to their neighborhoods than are clients' customers to the privileged home-based businesses. And Metro may not privilege more onerous involvement or interference with neighborhoods. Yes, Your Honor.
This is just a rational basis test, right?
Your Honor, it's not. This is a claim that's brought solely under the Tennessee Constitution, and Tennessee equal protection law is different, as the court has said. It's rooted in a pre-14th Amendment incorporation body of case law, which is more about the limits on the police power than it is about the 14th Amendment. And so in cases like Tester and Tennessee small schools, the Tennessee Supreme Court has said it's the real and substantial test, which finds its roots, again, in the early 1900s, late 1800s line of cases. And so that is a different standard than federal rational basis. Because it's a real and substantial requirement, it looks to, again, actual facts and looks to whether or not there is, as the test itself says, a real and substantial connection between, or distinction, that is germane to the purpose of the regulation. And so not just any old thing will do.
In terms of real, understanding the word real here, should we understand that as actual, true? And it seems under federal rational basis, it doesn't really matter whether something is true. It matters whether it's conceivably true. Does it matter whether it's actually true?
Your Honor, at summary judgment, I think it matters that it's actually true. I think the way that this test works in practice in Tennessee is that, yes, there is a presumption of constitutionality, but that is a rebuttable presumption. It can be overcome with a factual showing that demonstrates the lack of a fit or the lack of a real concern, or that the concern that the government says is important maybe is less important than shown. The upshot is, again, that the facts really do matter, and that although Metro may be able to speculate, we can overcome that speculation again, with the factual showing, which is exactly the way we litigated this case and exactly what we did below, putting forward a substantial, uncontested evidentiary record about the fact that my clients don't have the negative effects that Metro claims motivates it, and more importantly, that the privileged home-based businesses have in Metro's own admissions more of a negative effect than my clients do, and yet are less onerously regulated. That makes this case just like this court's decision in Consolidated Waste, where yes, there was a reason to regulate C&D landfills, but all of those reasons also presented with the other kinds of landfills that were not regulated the same way. And this court said, well, that's an equal protection problem. Sure, you can regulate them, but you have to regulate them the same to the extent that they are presenting the same concerns, the same reasons that are germane to the reason that you regulate. And here Metro says, we want to balance neighborhoods with home-based businesses operating. Okay, great. The problem here is that they've drawn different balances for similarly situated businesses. And how do we know that they're similarly situated? Well, we look at what Metro says it's concerned about, which is the effect that customers to home-based businesses would have on their neighbors. And the record shows that for each of the privileged home-based businesses, the Metro says there are problems, that they cause noise and traffic and
Do
parking.
we have a determination from the trial court as to whether these businesses are similarly situated? And does the trial court's order really engage with that question?
It does not, Your Honor. The Chancery Court really decided this as a substantive due process matter. It said, well, there are reasons to regulate home-based businesses. And it really doesn't get beyond that. It doesn't say, and there are reasons to regulate these folks different than these folks. And that's really the missing element. Again, the entire point of an equal protection challenge is that even if there is a reason to regulate, you can't regulate differently for similarly situated people. That's Consolidated Waste, that's Tester, that's Consumers Gasoline, all of which recognize there's a legitimate reason to regulate in this area. There's a legitimate reason to have a work release program in a jail. There's a legitimate reason to regulate landfills. There's a legitimate reason to regulate gasoline storage tanks. But that reason presents for everyone, and yet that's not the way that the regulation is happening. And so here there's really, I think, a two-part problem. One, didn't apply the right legal standard. This is an equal protection case, not a substantive due process case. And two, didn't look at the facts showing that equal protection violation here.
Counsel, I was struck, you cited Claiborne in terms of making an argument that this is actually violative, you suggest, I think, of the federal constitutional standard, though you're not making a federal constitutional argument. You're making a state constitutional argument, if I'm understanding that correctly.
That is correct, Your Honor. We have not made a federal constitutional argument here.
Isn't Claiborne inapplicable here? And it seems that Claiborne is part of a line of cases from Marino to Romer that really deal with rational basis where you have some sort of animus or prejudice, right? I mean, isn't that part of that line, whether you're talking about discrimination against unpopular individuals in Marino in terms of a counterculture movement, or Romer in terms of sexual orientation, and it isn't Claiborne essentially just an animus case against a politically disfavored group rather than really in the general stream of rational basis federal analysis?
I don't think so, Your Honor, and I don't think that's what the court says it's doing. What the court does in Claiborne, it says, look, this is a group home for the mentally afflicted, and it's being regulated a certain way. There are other kinds of group living that are regulated differently. But the reason the city gives for regulating this group home is that they will cause noise and traffic and parking crowding problems. But all of those reasons are also true in the same way as all the other group homes. And that means that's the equal protection violation. I think you can read into that behind the scenes, this must have been motivated by something else. But that animus idea that you're talking about isn't part of the court's analysis.
Is it really behind the scenes? I mean, doesn't the court engage with things like part of the rationale being that they didn't want young kids seeing people who were intellectually disabled, which is just an animus-based rationale in terms of supporting the local government law in the city of Claiborne?
Again, Your Honor, I don't think it is. As the court recognizes, yes, the mentally afflicted are different. But the question for the equal protection analysis, similar to here, is are they different in a way that applies to the government's interest in a different way? So is there does their difference cause a heightened problem such that heightened regulation is required? And at the end of the day, they say no. Certainly they are a different group. But when it comes to the government's interest, noise, parking, traffic, crowding, they are in fact the same, and that's the equal protection violation. And that's similar to the analysis that this court applied in consolidated waste. It's similar to what the Tennessee Supreme Court applied in Tester or in consumers' gasoline. All of those are cases in which there are differences. Take Tester, for example. There are differences in Tester between the counties that were part of the program and not a part of the program. That was, some of the counties had a metropolitan form of government, others didn't. But that form of government was not germane to the interest of the regulation, which was jail overcrowding. And the record in that case showed that the counties that were not a part of the program had just as much of a jail overcrowding problem as the counties that were in it. And so by the government's own tacit admission, it was treating similarly situated counties, similarly situated for purposes of the government's own interest in the regulation, differently. And that's the problem. And that's the same problem here. Again,
under McAllen and Fallon, the court's role is limited to determining whether any possible reason can be conceived to justify the ordinance. Are you arguing that that's inapplicable under your theory?
Your Honor, I don't think that's quite right. Those are cases in which they're saying that the government can, again, speculate as to reasons why a regulation would be justified. But none of those cases say, and you can't disprove that with facts. And that's what we're doing here. Tester says the government has proffered some reasons, but those reasons find no support in the record. And in fact, the record overcame the government's assertions about what the basis of the regulation was. And so that's the rule that we're asking this court to apply here. It's the rule that was applied in Tester and the rule that this court applied in consolidated waste, which is, yes, the government has theorized some reasons. Those theories don't find a root in the uncontested material record, and that's the reason why we've made our showing, we've overcome, and why we should be entitled to a win on equal protection.
Do you agree that the material facts in this case are not in dispute?
I agree that the material facts in this case are not in dispute.
Okay. Thank you, sir.
Thank you, Your Honors.
We'll hear from you on rebuttal. Ms. Fox? Good morning.
Good morning. Laura Fox, representing the Metropolitan government. Let me start out with the test for this case, Your Honor. Judge Bennett, you asked about that. And in the small schools case, the Tennessee Supreme Court said for the Tennessee Constitution, this is a rational basis test. So that's where we are today. And of course, that's very deferential to the local government. In this case, there is a rational regulation for these regulations, and these comparisons that the plaintiffs are drawing are simply incorrect. They wouldn't want to be these other businesses. They only want the different hours. They wouldn't want to have the requirements. This is not apples to apples. Let me start over. This is not consolidated waste where you had a C&D landfill and a heavier use landfill. This is not the Schatz case from 1971 with Tennessee Supreme Court where you had light waste storage and heavy waste storage. Those are apples to apples.
Did the trial court go through that analysis here, though? I mean, did the trial court really engage with the question of whether these were similarly situated or not? I mean, maybe the trial judge could look at these and say, you know, I don't think it is similarly situated. I think there's this important distinction between daycare facilities and somebody having a home recording studio. But did the trial judge really do that here?
I think if you look at the trial court transcript in the volume 25 in the record, it's very clear that the court has a very deep knowledge of the differences between these different kinds of uses. So does the order reflect that? Not as much as we might Monday morning quarterback those kinds of things, which I know is your whole job. But I think that to doubt that the court understood these distinct differences and in fact describe those differences is very clear in the record. She's very familiar with the daycares, the difference in the reasons for different regulations for daycares. She's definitely understands the short-term rentals differences. And the plaintiffs, again, they wouldn't want to be a short-term rental because there are a lot of regulations for a short-term rental. There's insurance, there's certain fire alarms. You have to have the fire marshal come to your house. There's a lot of things for daycares. There you could only be on a certain size street. The plaintiffs may not qualify for that. Historic homes, you have to be in a historic home. You can have evening events, but you have to go to the Board of Zoning Appeals and show that you have adequate parking and things like that. So there are differences. There are very real differences for why these different businesses are treated differently.
So does rational basis in Tennessee necessarily have to equate with rational basis in the federal courts in terms of how that standard of scrutiny is applied? And one of the things that strikes me is the use of the word real. Reality seems to have very little to do with federal rational basis analysis. It's what's theoretically conceivable. But the Tennessee Supreme Court keeps using the word real. Doesn't that make Tennessee's rational basis distinct from the federal rational basis analysis?
I think it could. I didn't see that in small schools, for example. I didn't see a distinction being drawn. So I think that this court would be taking a step away from what they said, which was that the analysis is identical.
What do we do with the word real then? Are you disagreeing that that's part of the test, that in terms of how we're supposed to analyze it?
I'm disagreeing that I don't see that as part of the analysis, but if we were to use that analysis, we have very real differences in here. These are not theoretical differences. What the plaintiffs want are longer hours, basically. They want to say, hey, short-term rentals get to have people for longer hours. But they don't want to comply, I don't think, with any of the other rules that short-term rentals have to apply. Special insurance, limitations on how many guests and bedrooms you can use, no food. There's a lot of regulations that short-term rentals have. So they go ahead and they compare themselves to businesses that are incredibly different, and they are really different. There are real differences between a daycare that's often state-regulated, where the clients, so to speak, the customers, the children, are staying all day long. You know the parents are going to come in the morning, and you know they're going to come in the evening, and they're going to come all at the same time. So you have to have some parking. You have to have some different requirements. So those are very real differences. And so perhaps the answer is you don't need to answer that question in this case.
What are the harms that are being addressed through the regulations what is it that the city is remedying?
Sure. Where we are in a situation is where traditionally in Nashville you could not have customers come to your home-based business. You just couldn't. Those were the rules for decades. And the Tennessee Supreme Court said that was a legislative decision that was up to the legislature. So what we have in this case is a very protective traditional system where customers cannot come to your house. So now the legislature has said, we're going to take baby steps out, and we're going to see how it goes, and we're going to let people have some customers come to their home-based businesses, but only certain kinds of jobs, such as personal services, recording studios, group exercise, so only certain categories and only certain hours. And that's because we, again, have a very strong tradition of protecting the residential features of our neighborhood. And I think it's also to protect commercial areas. If you really want to operate 7 days a week and you want to operate all days, go move to a commercial area. That's your choice. But when you want to operate in a residential area that's quiet and has neighbors, doesn't have special parking set up, you're inconveniencing your neighbor, and we're going to let you do these baby steps to allow you to have your home business and have your customers come to your place. So the harm is upsetting that balance. The harm is going full commercial and saying we haven't put in any of the protections of a commercial business, you don't have a parking lot, you don't have commercial insurance, maybe, we don't know if you have, if you're meeting ADA requirements and all those kinds of things, but we're gonna let you have a full commercial business where you set your own hours and can have as many clients as you want. That's not what the legislature decided to do. They decided to take these modest steps that would allow these folks to operate. So they can operate at a modest level, and I would say quite a reasonable level. I mean, they can have operations Monday through Saturday, really all day, but they can't have a customer every 15 minutes, like perhaps you would have in a commercial beauty salon. Does that answer your question as to the harm that the legislature might have been thinking of?
If we've got a circumstance as applied here where there's parking available in this person's driveway, and how is it undermining the residential character of the neighborhood to have somebody park in their driveway and come into the recording studio versus somebody come in and have a sandwich or tea with a friend? What's the way in which that's undermining the residential character? And if you've got people parking out on the streets, if you've got circumstances like that, and maybe it starts to look different. But under the facts here, if they have parking available, how is that undermining the residential character of the neighborhood?
Well, these are client visits, so you can have group exercise. So there may be more than one car. I think in a recording studio, you typically have several members of a band come. So I think it is different than having neighbors who, frankly, I think it's very likely that when you have people visit your house, they're often the same people. I don't think that you put out an advertisement to say, anybody want to come to my house this weekend for a party? That's not what we do in our neighborhoods. We count on our neighbors to bring trusted people to the neighborhood and not strangers. So when they're bringing
isn't
someone.
Isn't that different with short-term rentals? I mean, aren't short-term rentals bringing in people who are different over and over and over again? You've got new folks coming in.
Yes, and the basis, if you look at the short-term rental ordinances, every time that the council touches short-term rentals, it's because of the shortage of hotel rooms in Nashville. And so there's a very distinct governmental interest that has been expressed for why we're going to let people come and spend the night in a residential house. And in fact, the owner has to be there at that time. And again, there's a number of restrictions. You have to have all the fire safety. You're treated more like a hotel in those circumstances. That's not what the plaintiffs are in this situation. The plaintiffs can be anywhere in the county. They don't have to go get special permission. They don't have to be on a special kind of street. They don't have to show that they have adequate parking. They can be anywhere in the county, and they can get a permit and have, and by right, they can have this ability to have people come to their house. And so I think that you see that the council is trying to strike a balance, and it's a difficult situation, but I mean, it is hard to strike that balance because I think that one of the reasons they allowed customers to come to the house was during COVID. People saw, oh, maybe people can work from home. Maybe this can work. And so I think that there was much more willingness to give this a try. And so they did give it a try on a test basis, and now they've said, yes, we'll go ahead and have this. It originally was there was a sunset provision, and now the legislature, the Metro Council has said that this program can continue. But again, that's the legislature's role to determine how to set this balance. And the plaintiffs here want to cherry pick longer hours, more customers. They want to cherry pick the parts that they think are similar to these businesses when they're really not similar at all. Because again, there's distinctions between, we're not comparing recording studio to recording studio. A daycare is an entirely different business with entirely different business model and restrictions. And so I think that those are the kinds of things that the council was thinking about when it made this decision. There are rational reasons to support this balance, and the council made those determinations, and it's not the court's role to be a super legislature and change the business hours. I mean, are you going to say, well, instead of 6 p.m., we're going to let you operate till 8 p.m. because we think you're great? It's the council members who are in touch with the neighbors and work really hard to make these balances and determine what is best for the neighborhoods who should make those decisions. So in conclusion, they've made this decision to make a modest allowance for customers to come to the house. They're trying to preserve the residential neighborhood, which is a strong Nashville tradition, and equal protection is not violated. We're not comparing apples to apples. We're just not. They call these businesses they called privileged may have longer hours, but that's about the only thing they'd like to have as far as what they offer.
Counsel, did the facts in this case, the undisputed facts in this case, establish that, and we've talked about sort of negation of the harms, do they also establish the benefits of the exception? So if we look at the undisputed facts, is it going to say inadequate hotel space? That's why we needed to provide this exception for short-term housing. Inadequate daycare facilities. That's why we need to have home-based daycares. Is that also stated as a fact in terms of the local purpose behind these exceptions?
I think that those elements are in the record, but they're in the record as part of the Metro Code. So when I draft a material statement of material facts, I don't include the law in my facts.
Is the purpose stated in the code itself? Does it lay out that short-term rentals being necessary because of inadequate hotel space? And do we have that it's in the Metro Code, that purpose?
That's definitely in the ordinance, which I believe is in the record.
Okay.
Thank you, Your Honor.
Oh, thank you, Ms. Fox. Mr. Abelar?
3 points, if I may, Your Honors. First, Ms. Fox talked about the hours restrictions in the regs. There are 3 different restrictions that we're challenging here, and I didn't hear anything really about the other 2. There's the keep and turn over the log requirement. Again, the purpose of that is sort of uncertain, but whatever that purpose is applies equally to the other kinds of home-based businesses who also have restrictions, albeit greater restrictions on the number of clients they're allowed to have. And so as the trial court pointed out, it doesn't make a lot of sense from a regulatory standpoint. We haven't heard anything about it today. The second is the 6 and 3 client restriction, and there's some confusion about this as to what exactly the customer visit restriction is. And Ms. Fox said again, you can have more than 1 customer per customer visit, but the upper bound on that is unknown, it's uncertain. It seems to be unlimited. And so if that is true, we would ask that this court say so expressly so that my clients can rely on Metro's assertion about how many customers they're allowed to have a day. Because right now, they think they're only allowed to have 6 customers per day and 3 per hour or at a time. Metro says, no, you can have way more than that. We don't know what that answer is. And so if it really is the case that my clients can have way more than that, that's fantastic. But we need to have a court say that expressly. No court has said that yet. We're only left with Metro's representation of what the law is. And if Metro is correct about that, it really undermines everything they said about the preserving neighborhoods because too many customers, et cetera, et cetera.
Would the log requirement be there in order to allow Metro to enforce the customer restrictions?
That seems a logical supposition, Your Honor, but the problem is that other businesses that also have a customer restriction are exempt from it. So
I understand your statement.
But that would be, I agree that under a substantive due process rationale, that may be sufficient, and then we can talk on the back end about whether something like a Fourth Amendment might apply. But here, for equal protection purposes, if that is the purpose of the keep and turn over a record requirement, it applies equally to these other businesses. They are exempt. That's consolidated waste. The second point is that Ms. Fox said we wouldn't want to be these other groups. Well, my clients did apply to be SPs and were denied. That goes to show that these other businesses, these other restrictions are more favorable to my clients than the ones that they're required, even though they're similarly situated.
Counsel, I want to ask you a question about real difference here in terms of, it seems like a lot of your argument is focused on addressing the harms in terms of my clients' businesses don't do this harm, they don't do that harm, therefore this doesn't meet the demands of equal protection. But isn't Ms. Fox right in terms of part of the balancing here is the benefit in terms of what does the city get through the exception? And so if there is an advantage, there's inadequate hotel space, well, recording studio doesn't do anything to address that harm, and we're balancing interest. Why isn't that enough to render this constitutionally permissible?
Your Honor, I would look at the germane prong of the equal protection analysis in Tennessee, and that's actually my third point. What Ms. Fox says, there are other issues here, right? Other businesses have to get special permission, they have to have insurance or something like that. None of that goes to what Metro says it's trying to do with restricting home-based businesses, and specifically restricting customers to home-based businesses. Nothing that Ms. Fox just ran through goes to the effect that customers have on a neighborhood, customers to home-based business have on a neighborhood. That's the thing that Metro says it's regulating, and so any of its interests have to be, that's its interest, we're looking at what's germane to that interest, and the record shows that not only are my clients specifically less burdensome, but that as a category, home recording studios, home salons are less effective of neighborhoods than are the privileged home-based businesses. And so it's the germane prong that I think your honors should be focused on. I'm happy to answer any further questions that your honors may have.
Hearing none. Thank you, Mr. Abelar and
Thank you,
Ms.
Your Honor.
Fox, for your arguments. We'll take this matter under advisement.
Thank you.
Call the next case, please.
In re Estate of Joyce Ann Hendrickson.